Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about are the circumstances in which you can modify child support here in Connecticut. So I'm just going to show you the statute that is relevant. It's 46B-86. And some of this applies to modifying alimony, which I'm not going to talk about today, so that's why I'm only going to go over the highlighted portion. So it says that any final order for periodic support or an order requiring either party to maintain life insurance for the other party or a minor child of the parties may at any time thereafter be continued, set aside, altered, or modified by the court upon a showing of a substantial change in circumstances of either party. So basically, the key language there is substantial change in circumstance. So you can modify child support in Connecticut when you can establish that there has been a substantial change of circumstances. So I'll now get into what that means exactly. So it's basic. There's an infinite number of things that could happen that would, be considered a substantial change in circumstance, but there are several that are most common. The most common one probably is just a change of income. So, let's say you are earning child support from your former spouse, and that person gets a significant raise where they're making $150,000 before, and now they're making $250,000. So that would presumably be a substantial change in circumstance that would warrant a modification of child support, because child support is based on the income of the parties. They look at your income to calculate child support. So moving down lower in the section, it says, there shall be a rebuttable presumption that any deviation of less than 15% from the child support guidelines is not substantial, and any deviation of 15% or more from the guidelines is substantial. So let me explain what that means. I'm going to bring up a calculator here. So let's say the existing child support order is $250 per week. In order for it to be considered a substantial change in circumstance, there has to be a more than 15% change to that weekly amount. So you look at it and you say, okay, it's $250 per week and 15%. So you multiply that times 0.15. So that's $37.50. So the new child support guidelines would have to be either, to warrant a modification, they would have to be either $37.50 more than $250 per week, or you might be filing a modification based on somebody earning less income, in which or yourself earning less income, in which case you'd be seeking a decrease. But if it's a less than $37.50 change in either direction, there's a rebuttable presumption that there is no substantial change in circumstance. So you figure that out by plugging in the new incomes to the guidelines and seeing if that 15% is met. So again, it would be, you do 250 plus 37.5. So if you're going up, the new guidelines would have to be more than $287.50 a week, or you do the reverse if they're going down. So, but that's not the only change in circumstance. Another common one is if there is a change of custody. So let's say, father is receiving child support from mom, and there's been, a change of custody for some reason. Well, in that situation, you are presumably going to want to switch it so that, the parties are paying child support in the opposite direction. And that would be a change in circumstance that would warrant a modification. Another one is a child ages out. So once a child ages out of child support, so it's, once your child reaches age 18, they're no longer eligible for, child support payments. unless they're 18 years old and still in high school, in which case the child support ends upon high school graduation, unless they turn 19 when they're still in high school, and at that point, child support would end at 19. So if a child ages out, that's a substantial change in circumstance that would modify, that would warrant a modification. So let's say you have 3 kids and one child ages out and you then have 2 kids. You have to actually proactively file a motion to modify to change that child support amount. The only circumstance in which you don't have to file a modification is if your last child ages out. So let's say you have one child and one child for which child support is still being paid, and then that child ages out. You don't have to file a motion to modify. You can just stop paying child support. But if there's still some child support obligation based on a child still being eligible for child support, you want to make sure that you file the modification. Don't just cut child support in half. That's not how it works. It's not just cut it in half. If you go from 2 children to 1 child, you need to make sure you file the appropriate motion. But again, those aren't the only circumstance. It could be, let's say your spouse comes into substantial assets. Let's say they're making minimum wage and you're receiving child support from them based on their minimum wage income, and they inherit $5 million from their parents, for example. So that could be considered a substantial change in circumstance, in which case you could seek more child support. So again, it's an unlimited, kind of universe of things that could happen. A good place to look for examples of changes are on the bottom of so if you go to the Connecticut Child Support Guideline worksheet, you can Google this. If you go to the bottom, you can see deviation criteria, which I explained in another video about child support, that you can deviate from the presumptive child support guidelines based on certain things. But if you look here, these are examples of, changes of circumstance. So somebody comes into substantial assets, or, educational expenses change. Let's say, your child, something happens, they get into a fancy private school or something, and, or, let's say your child becomes disabled. That's obviously a different one. But if your child becomes disabled, or you become disabled where your income doesn't necessarily change. Let's say you were on a fixed income before and your income doesn't change, but perhaps your expenses have changed. That's an example of a substantial change in circumstance. So based on this substantial change in circumstance, you can modify the weekly child support amount. What you can also modify is the percentage contribution towards certain expenses. So generally when you enter a child support order, it's X number of dollars per week in child support, but then each party contributes a certain percentage to work-related childcare and unreimbursed medical expenses, as well as extracurricular activity expenses. Those aren't necessarily the same as the guideline percentages, the extracurriculars, but there are these 3 kind of extras for which each party contributes. Again, it's work-related child care expenses, unreimbursed medical expenses, and extracurricular activity expenses. The first 2 of those are usually based on the guidelines, which the percentages will look at each party's percentage of the total net income after child support is paid. So again, on a separate child support guideline video, I will explain that. But that is something that can also be modified in addition to the weekly child support. It's the percentage contributions towards those extras. And then finally, you can ask for retroactive support when you're filing a motion to modify. So there shall be a rebuttable, that's the wrong section. No order for periodic payment of support may be subject to retroactive modification, except that the court may order modification with respect to any period during which there is a pending motion for modification of a support order from the date of service of notice of such pending motion upon the opposing party. So what that means is basically, okay, you file a motion to modify child support. You first file the motion and you're assigned a court date. After you're assigned that court date, you have a marshal serve the opposing party. So you can ask that, let's say you don't have a hearing for 6 months. Well, you're kind of out of luck for those 6 months, but you're not out of luck because you can ask for the modification to be retroactive back to the date of service. So they might find that the opposing, let's say it's an increase in child support that is ultimately happens. They will find that they'll say, okay, you went from $250 a week in child support times, to $300 per week. So that's $50 a week increase. And let's say the opposing party was served 10 weeks ago. So they say, okay, the new child support is $300 per week. But, we find that there's a retroactive amount owed of $500 based on that, $50 per week increase times 10 weeks since the date of service. So you can ask for that retroactivity. So those are the basics on how, the circumstances in which child support can be modified. I have a separate video that should just be titled, motion for modification, that shows you how to actually draft and file the motion. So if you want to see that video, look that up separately on our YouTube page or on our website. And as usual, if you have any additional questions, feel free to give our office a call and we'd be happy to answer those questions.